I filed a motion to modify probation as well on another case that she has. We were having problems with e-file yesterday, so it may have been very late in the day. I don't know if it made it, but it's...
I received it this morning, Your Honor. I can tell you what it is. We kind of discussed this with Ms. Simmons earlier this morning. Ms. Taylor pled a couple months ago on, I think, 2 other cases, and got probation. She was ordered to safety. Before she could get sent to safety, this case got indicted, and that kept her here. This case was indicted about a month ago, first week in November.
Okay. Offense date of
March predates what we did before.
predates it. Okay.
It was part of the backlog of testing from the lab.
Yeah, and so the agreement on this one is
To run concurrent with what she's doing, which I think this is a 10-year deferred, concurrent with what she's already doing. Mr. Galmore's position is that since she's had to wait a few extra months in custody and not able to go to safety as ordered, he's asking that safety condition be switched to maybe ISF or something else if the court deems appropriate.
so what I would do at that point is it would get reset for sentencing and they would have to do a new substance abuse evaluation. If you want me to, I need probation's input. If their recommendation previously was for safety, then she hasn't received any treatment. I understand that she's been in custody, but that's not treatment. And so if she's going to get a probation on a possession to go along with that, there's going to be some treatment, and I would anticipate it would be in custody treatment.
And that's what my motion on the motion to modify probation was suggested, was an alternative treatment program that just may be shorter. I think the real reason for the argument would be the fact that she is farther removed from her drug use at this point than it was originally considered.
I would consider ISF, but I'm not going to do outpatient. I think we need something with 2 felony probations that's a little more intensive.
The shorter ISF program would probably be about the same amount of time that was originally planned for her to be in custody anyways.
Right.
And so that was one of the requests that my motion made in the motion to modify. And then we left the treatment plan on this plea up to the court.
So is there any reason to get even an updated pre-sentence report? I can just go ahead and do all of this.
She's been in custody this whole time, so there's nothing that's been changed.
Right.
I know no major disciplinary problems or anything like that,
Yeah.
so I would ask the court to go forward today.
Okay, all right, let's take care of the new case and then we'll discuss the modification. Then, you're Melissa Taylor.
Yes, ma'am.
And Mr. Galmore, will your client waive the formal reading of the indictment?
Sure, Your Honor.
Ms. Taylor, in cause number 25, DCCR 1693, you're charged with a 3rd-degree felony offense of possession of a controlled substance from March 9th of 2025, and how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Galmore?
Yes, ma'am.
Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And the agreement is for a 10-year deferred probation. Is there no fine on this one?
I'm okay with waiving the fine.
All right, there would be no fine on this case, and you would be required to follow all of the rules and conditions of probation, which, as you guys have said, is unagreed as to treatment, but that we've talked about. What I'm inclined to do is the substance abuse track of the ISF program. Is that your understanding? And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Any evidence that Ms. Taylor is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. I am going to waive the pre-sentence report. I'm going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for a period of 10 years. You're ordered to follow all of the rules and conditions of probation, which include entering and successfully completing the substance abuse track of the ISF program. In addition, as your follow-up treatment, when you get out, you will be required to enter and successfully complete the JCDI program. So you're going to get out, you'll have all the tools, you're going to get tools while you're in custody, you're going to get out, you're going to have even more tools so that you can be successful and get off drugs for good be a productive member of society, and not end up with felony convictions on your record and going to prison. And if you do all of that, just like we talked about in the other case, this is a great opportunity because you don't have the conviction on your record. If you successfully complete the probation, the case will be dismissed. You'll never have a felony conviction. The other side of that is if you violate any condition in this case, you'll be brought back into court, you could be found guilty, and you could go to prison for between 2 years and up to 10 years. Do you understand?
Yes, ma'am.
All right, I'm handing you, in that case, the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. Yes, ma'am?
May I speak?
Let me, hold that just a second. Let me take, because I'll get sidetracked and then I won't do what I need to do legally. So now, for probation in cause number 24, DCCR 2311, I am going to grant that motion to modify the probation order to change that from SAFE-P to ISF, substance abuse with JCDI as aftercare.
Will you give me the call number?
24 DCCR 2311.
Judge, I think there may also be another probation that she's on, a different cause number.
I'm not sure.
I thought we pled her to a state jail and a.
Can y'all look,
higher level
please?
felony. I just don't want, I don't want to get skipped over if there's another.
If she's on probation for more than that one, if there is another, and then the same order goes for all. If it was SAFE-P, that can be
No, this one or two.
switched from SAFE-P to ISF substance abuse with JCDI as a. The problem is if it's a. Do y'all think there's one? Because it might be the time that she's on probation could be an issue. Okay.
I could be wrong.
Okay, we'll double check it. If she is, that'll be a condition. It'll be switched from SAFE-P to ISF also. Okay, yes, ma'am.
Yes, ma'am. So I have been incarcerated for the last 8 months in Jefferson County Correctional. During the last 8 months, I've held a trustee position for 6 of those 8. There are no programs for rehabilitation for women like myself that spend 8 to a year incarcerated. There are none. The completed literature that I put down, I went out of my way to obtain that, get those shipped into me, to reach out to an outside sponsor to review my packets that I went through. I have, whether you go to a 9-month program, a 6-month program, or a 3-month program, the desire of the individual to change and putting these into application are what actually creates lasting change. Otherwise, they're just books that I've read.
Sure.
If you can ask me anything about these books, and I can tell you how I've changed and how they've changed me and what they've done. I realize that my addiction is a terminal disease that will kill me. And it is a lifelong recovery process. And that if I don't completely abandon myself to my higher power in a recovery program for the rest of my life, that I will end up in prison or dead. I don't have any more options. I agree that I will most likely learn something from ISF. I will learn from any program that I'm ever put against. But I am begging you with the effort that I took, seeing that there's no options for female inmates other than an AA program every other week at best. We sit in there and we eat and we gain weight and we watch movies and it's a vicious cycle. I understand the triggers and what made me relapse. I have a phenomenal support system, and I am willing to go so far to say that if you give me the color program, and if I fail, take this all away and put me in prison for 5 to 10 years. Don't have it as an option.
Mr. Nichols, so
Big red letters on
So
the
here's the
file.
thing, Ms. Taylor, the words that you're saying
Right.
are, no, I mean, I can tell that you're sincere. I hear people say those words somewhat often. I wish more. Sometimes I feel like they're sincere, others I don't. I agree, there are not programs because jail is just a rotation. of coming and going, and it's hard to get programs going because by the time someone gets started, they're probably leaving, and it could be better. I appreciate what you've done. I'm inclined, but here's my fear, is that I don't want to do what you're asking and set you up for failure. So if I do what you're asking and you violate, there's going to be a notation about all of this. Mr. Nichols will remind me, probation will remind me, and there won't be, okay, now I need SafeP. Now I need ISF.
I'm
Mr.
that
Nichols?
dedicated to my recovery.
You know, I usually have a pretty good memory for these things, Judge. If the court wants to give her that shot, I don't want to have to revoke her. I want her to be successful. I've read what she provided the court. I know it's impressive, the work she's done for herself while in jail. I'd hate to see it all fall apart, though. I mean, I think the case she's on, other case she's on probation for is assault on an officer. And I know there was at least one state jail.
I do have,
drug
so
related
24
justice.
DCCR 2177 is another, she's on probation for. There is another probation. And so 24 DCCR 2177, so whatever I do to modify conditions are going to be the same on those. So I guess what I'm going to do, Ms. Taylor, is I'm going to give you this opportunity. It's 100% up to you to take it. Otherwise, you have 3 felonies that you're going to go to prison for.
That will be a success.
And here's the thing. If you feel like you're slipping and you need more and you go say, I need SafeP or I need ISF before it ends up with me, that's one thing. That's a hard decision to make. But if you're truly committed to it and you feel yourself slipping that you need inpatient, it's going to be up to you to make that decision to ask for it. If it gets so far that you're here, it's going to be too late. All right, so then I'm going to modify the conditions of all of those probations, including the new case, to order that Ms. Taylor enter and successfully complete the JCDI program and not have to go to ISF or SafeP in any of them. So take advantage of this. I did everything else.
I think so.
All right, good luck.
Yes, ma'am.
There's two old probations, the 2 prior ones, and 1 new one. So we've got 3. All right, so we're going on.
Yeah, it's a third degree.
Okay, so more of that. All right, so are you Perry Robertson?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
Your Honor.
Mr. Robertson, in cause number 25 DCCR 0498, you're charged with the state jail felony offense of evading arrest or detention with previous convictions, and that's from March 23rd of 2025. The indictment alleges you were previously convicted of evading detention February 23rd of 1998, and then again January 10th of 2000. And then it further alleges you were convicted previously of possession of a controlled substance, a state jail felony, April 22nd of 1999. Then after that was final, you were convicted of delivery of a controlled substance, a state jail felony, November 20th of 2000. And then after that, possession of a controlled substance, a state jail felony, November 4th of 2003. And then convicted of 2 delivery of controlled substance, state jail felonies, June 13th of 2005. After that, convicted of possession of a controlled substance, a state jail felony, February 19th of 2008. Again, convicted of possession of a controlled substance, a state jail felony, April 12th of 2010. And unauthorized use of a motor vehicle, January 7th of 2010. And then finally, possession of a controlled substance, a state jail felony, July 29th of 2024. And how do you plead to that charge? Are all of those prior convictions true? Did you enter your plea of guilty and true to all of those convictions freely and voluntarily?
Yes.
And because they're all actually true?
Yes.
All right, I do want to know, what was that what did he get last year?
Wait, I believe
Possession of a controlled substance, July 29th, 2024. Cause number 24, DCCR 0025.
state jail. State jail, Your Honor.
State jail
Give me
time.
a second.
Yes, they did.
Okay. You ever been to TDC on any of these cases? Okay. So you understand if I follow that agreement, you're waiving your right to appeal, right?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Robertson is not competent?
No, Your Honor.
And the agreement is for a dismissal in 0499, correct?
No, there's
No, he's
two
pleading.
cases.
Two cases, Judge.
What did I just read?
CC.
Oh, to run CC. Sorry. Let me go through. So then, that helps me. Hold on. I got to write this. All right, in clause number 25, DCCR 0499, you're charged with, give me a second, the state jail felony offense of burglary of a building from March 7th of 2025. This indictment alleges all of those same prior convictions that I read out previously. And how do you plead to this charge? And again, are all of those prior convictions true? And are you entering your plea of guilty and true in this case freely and voluntarily? State tenders number one in that case as
No
well.
objection.
It's admitted. Any evidence that Mr. Robertson's not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. And cause number 25, DCCR 0498, find you guilty of the state jail felony offense of evading arrest or detention with previous convictions. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25, DCCR 0499, also find that you entered your plea of guilty freely and voluntarily and those pleas of true. Find sufficient evidence to find you guilty, and at this time find you guilty. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you in each of those cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. They will run concurrently, which means together at the same time. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right? Good luck to you, sir. You can go back with Bailey. Good morning. Are you Burton Edward Bailey?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, excuse me, he will, Your Honor.
Mr. Bailey, in cause number 25, DCCR 1380, you're charged with the state jail felony offense of theft of property with previous convictions, and that's from August 9th of 2025. The indictment alleges you were previously convicted of theft May 13th of 1991, and then again January 11th of 2024, and then August 29th of 2024. And then it further alleges that you were convicted of possession of a controlled substance, a state jail felony, October 2nd of 2008, and after that was final, convicted of possession of a controlled substance, a state jail felony, October 26th of 2011. Convicted of delivery of a controlled substance, a state jail felony, May 11th of 2012. Convicted of possession of a controlled substance, a state jail felony, October 5th of 2018. And then convicted of possession of a controlled substance, a state jail felony, July 31st of 2024. And how do you plead to that charge?
True.
Well, are you guilty or not guilty of the theft?
Guilty.
Okay, and are all of those prior convictions true that I read out?
Yes.
All right, did you enter your plea of guilty and true freely and voluntarily?
Yes.
And did you plead guilty and true because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
I need to know what some of those prior punishments were. I feel like this is incredibly low for that amount of criminal history.
I'll let you know, Judge, that we took into account, I'm not sure prior with you, but we took into account, and Mr. Rojas can speak to this, the nature of the underlying offense, theft of clothing and cleaning supplies, Your Honor, from a, I forget the name of the establishment, but nevertheless, to answer the court's question, well, here, I'll just give you this.
Well, let's start with the last one from just July of a year ago, 2024.
77 days on that particular theft.
Okay. And then that's the only Jefferson County. We've got some Tarrant County.
In the interest of full disclosure to the court, it does have a 1994 federal conviction for what they term or refer to as take motor vehicle by force. He did 140 months on that. And then on his supervised release, when he was released from that 140 month sentence, his supervised release was revoked to a 10-month sentence, Judge. Again, the state's thinking was the underlying nature of it.
No, I understand that. I just, do you know the Tarrant County?
What year was that?
The 18, there's one from 18.
I'll show a POCS from 2018. He did 6 months in jail.
Okay.
Probably state jail.
Yeah, they were all state jail, so it's,
He does have one real felony that did 5 years on. That was back in 1991, Judges Denolin.
That's right.
okay,
That in the federal case are the only substantial time he's got.
okay. All right, Mr. Bailey, do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Bailey is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of evading arrest with previous convictions. Find all of those prior offenses true. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows these were agreement, or this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. Thank you. Thank you, Mr. Coleman and Mr. Rojas. Good morning. Are you Tristan Calhoun? And will your client waive the formal reading of the indictment in each case?
He will, Your Honor.
Mr. Calhoun, in cause number 25, DCCR 1216, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from August 2nd of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And because you did what they charged you with? And then in cause number 25, DCCR 1217, you're also charged with the second-degree felony offense of aggravated assault with a deadly weapon from August 2nd of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? Bless you. I have here on the tablet some documents that have your signature on them in each of these cases that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreements that you've reached with the district attorney's office, you will be waiving or giving up any right to appeal?
Yes, ma'am.
So you can't change your mind if I follow the agreement. You understand?
Yes, ma'am.
And it looks like the agreement that you've reached in each of the cases is for 7-year deferred probations. There would be $500 fines. There would be, you'll be required to follow all of the rules and conditions of probation, including paying any restitution that would be determined between now and when we come back for sentencing, and also having no contact with the victims in either of the cases. Do you understand?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Calhoun is not
No,
competent?
Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your case, both of them, for sentencing so that the probation department can do a pre-sentence report. Again, that'll give me more information about you, your cases, determine any restitution, and then we'll come back later for sentencing. What's the state's position, Ms. Malfino, with regard to bond based on the nature of those plea agreements?
Judge, I have no objection to the PSI bond in this case. It appears he only has one misdemeanor conviction from years ago. For my review of his criminal history, I would ask, as the court has already stated, that he not have any contact with Sierra Williams or Keithera Fowler, the complainants in these cases. It doesn't appear that these parties know one another. It appears like this is more of a road rage, traffic accident gone wrong type thing.
What was the first name, Sierra?
Sierra Williams and Keithera, Keithera Fowler.
The indictment on that one says Ardwan as the last name. And yeah, that's the 1217. And I can just put both.
Yes, it does. So she must go back in there.
Okay, so Fowler, Ardwan.
Correct.
All right, so
And then
he,
he not, I'm sorry, excuse me.
Sure.
He not possess a weapon because it was involved in this case. I will get together the necessary documentation to assist PSI.
all right.
I think the car was still dead. They're alleging the
Was-
car.
The motor vehicle,
They're alleging the car was still dead. It was.
let me look at the probable cause.
There's a,
There-
yeah.
I can't read this. I'm printing something real quick.
Yes, ma'am.
So what I'm going to do while I'm printing that is, Mr. Calhoun, I'm going to reduce your bond in each of these cases to $1,000. If you make those bonds, a condition of those bonds are that you obviously have no contact or communication with Sierra Williams or Keithera Ardwan Fowler. Give me just a second. I'm taking that back. I'm not gonna change the bond because there's the potential of some type of upfront, either treatment or cognitive issue. I mean, what happened on this day this is pretty serious. Yeah, and so, the bonds are going to remain the same. I'm not gonna reduce those bonds. We'll see what the probation, what that report comes back, and if I feel like there's anything that is necessary or would be helpful for you to be able to make better decisions, be successful in the probation, then I'll order that at this time, but I'm not going to reduce the bonds based on what happened that day. All right, you can go back with the bailiff. Good morning, you're Donnie Williams. And Mr. Parker, will your client waive the formal reading of the motions in each case?
Yes, Your Honor.
Mr. Williams?
The charges are all the same in each case, Judge.
Yeah, I got to go through them. Okay. In cause number 22-40823, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation February 13th of 2023 for forgery of a financial instrument, a state jail felony. That was a 2-year sentence that was probated for 5 years. Is that correct? And in cause number 22-41018, I also have a first amended motion to revoke your community supervision. Again, also shows you were placed on probation February 13th of 2023 for forgery of a financial instrument, a state jail felony. And again, that was a 2-year sentence that was probated for 5 years, correct? And then cause number 22-41019, also have a first amended motion to revoke your community supervision. Also shows you were placed on probation February 13th of 2023 for forgery of a financial instrument, a state jail felony. That was a 2-year sentence that was probated for 5 years. Is that also correct? Speak up, please. Thank you. All 3 of these motions allege that you violated your probation. Count 1 alleges in each case that you failed to report as directed to the probation department December of 2024 and January of 2025. And is that true or not true?
True or not true?
True.
Count 2 in each case alleges that you failed to provide verification of completing the theft program or the theft prevention class. Is that true or not true? Count 3 in each case alleges that you did not provide verification of entering and successfully completing the moral recognition therapy. Is that true or not true?
MRT program.
MRT. True.
That's what we're talking about.
Count 4 in each case alleges that you are behind in your court-assessed fees. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 4 in each of these cases freely and voluntarily? And did you plead true because all of those counts are actually true?
True.
In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed those, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1 in each case.
Objection.
It's admitted in each case. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, Mr. Williams, in each of your cases, I'm going to find that you enter your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to revoke your probation. In cause number 22-40823, revoke that probation, reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 22-41018. Find sufficient evidence to revoke your probation, and at this time revoke your probation, reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 22-41019, find sufficient evidence to revoke your probation, and at this time revoke your probation, reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence also for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you the trial court certifications in each of these cases that shows these were agreements that I followed, and so you've waived your right to appeal. When you entered your pleas in these cases, I went over with you the fact that you're ineligible under Texas law to possess a firearm or ammunition. I'm attaching a copy of that because of the judgments. You are ineligible to possess a firearm or ammunition, and if you have questions about that, you can read that document or talk to Mr. Parker. All right? Good luck to you, sir. You can go back with the bailiff.
Thank you, Judge.
Thank you. How do you say your first name?
Isis.
Isis? And you're Isis Traddles? And Mr. Parker, will your client waive the formal reading of the indictment?
She will, Your Honor. Oh, did I get you.
I got her. Ms. Traddles, in cause number 25, DCCR 1478, you're charged with a state jail felony offense of injury to a child from July 21st of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation, which would include entering and successfully completing an anger management program. You understand? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Judge, I'm sorry to interrupt the plea. Your Honor, I just realized that there's information in my file that indicates restitution for the hospital bill for the child. I shared it with Mr. Parker. It's $346. I don't know if we want to maybe put this on hold.
Well, so I'm going to reset it for sentencing, and that can be confirmed with probation between now and sentencing. And then just make sure they know about the restitution amount. So if there's any restitution between now and sentencing, they'll get that figured out, and it will be ordered if there was any restitution. You understand?
Oh, so you say I'm gonna have to pay that?
What? I'll tell you. They're going to look into that. They're going to reset it.
They're going to look into it. If there was something that had to be paid or is owed because of what you did, that insurance didn't cover or whatever it is, then yes, you're going to have to pay it. And I'm going to make that notation on the agreed punishment recommendation that I've said restitution to be determined, if any.
Your Honor, we're requesting a personal bond.
Hold on,
also.
let me get there.
I'm sorry.
Okay, did I already ask about,
Immigration.
Immigration.
That's where you left off, Judge.
okay. State tenders number 1,
No,
it's admitted. Any evidence that Ms. Traddles is not competent?
no, Your Honor.
Ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Coleman, what is your position with regard to bond?
The state's unopposed to either lowering the bond or a personal bond. Judge, she has no criminal history. In fact, information in my file indicates that she was cooperative with law.
So where is the child now? Who's he living with? Okay, so this wasn't your child. Do you have any children? All right, so here's what I'm going to do. I'm going to reduce your bond to $1,000. I'm going to make that a personal bond, which means you do not have to pay any money to get out. If you don't show up to court, you're going to have to pay the $1,000 and they'll come after you. But you'll just be released today. But there's some very important things about that. So the first thing you do when you're released is go to the probation department so they can get that pre-sentence report done. If for some reason it's later in the day, then go first thing tomorrow morning. But if it's not, then go straight there this afternoon. You'll get some paperwork today that tells you where to go. If for any reason you don't follow through with that report, then you run the risk of me not accepting the plea agreement and things could be much worse. You understand? Also, if you're arrested for anything between now and the time that we come back for sentencing, you run the risk of me not accepting the plea agreement. You understand that also? And then finally, between now and sentencing at least, I am going to order that a condition of your bond is that you not have any unsupervised contact with any child under the age of 18. Now, that obviously may change in the future, but just for between now and then, I don't want any unsupervised until I know what we have in place and I can find out more about the case. Understood? All right, you can go back with the bailiff. All right, are you Robert Lowe? And so Mr. Lowe was previously in court, entered pleas of guilty to 3 cases of possession of child pornography. There was an agreement in those 3 cases for a 7-year deferred probation and a $1,000 fine with dismissals, I think, in 3 or 4 other cases. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
I feel like this is different from some of these types of cases because Mr. Lowe was actually involved in creating with his own family member victim who was very young, 5 years old. So this wasn't I downloaded something and didn't realize what I was downloading. This is very different. This is a family member that was victimized because of this. Don't talk right now, okay? And so for those reasons, I do not feel comfortable accepting deferred probations in these cases. So I'm going to reject those plea offers. I don't know, honestly, I haven't thought more about what I would be amenable to other than potentially just letting a jury decide. I'll reset it one time. You guys negotiate, see where you are on it. And if you come up with something, you can contact me. Otherwise, we'll get rejections and get his cases set for trial and let a jury decide one way or the other. Okay? I'm just not comfortable with this at all. You can go back with the bailiff.
But I already signed for probation.
I don't have to accept your probation.
I wasn't told that.
Yeah, you actually were, because we reset your case for sentencing. And here's the thing. It doesn't matter if you were or not. I'm not accepting the plea agreements. Okay? There's nothing you can do at this point other than Ms. Holmes will be out there to visit with you about any other options. And if you don't like those options, or if I don't like those options, then ultimately that's what a jury is for. If everyone can't agree, and then we get a jury to come in and determine if you're guilty and what the punishment is if you are found guilty. Okay? So let's see where we're. I'm not going to consider any bonds at this time.
Yes, Your Honor. I just, his mother is here, and so, but just for the record, because I have spoken with her on several occasions, as well as with Mr. Lowe. They did keep asking me if he would get out today, and my response to both of them was that it's up to the judge at the end of the day. So
Thank you, Ms.
I told
Holmes.
you that yesterday
Yes, ma'am.
when I visited with you,
Yes, ma'am.
and I told that to your mother.
Yes, ma'am.
That ultimately it's up to the court on whether you would be released today and placed on probation.
Yes, ma'am.
Thank you, Ms. Holmes. You can go back with the bailiff.
I can't say nothing else.
It's probably not wise right now. Okay? Go back with the bailiff. I'm going to delete the other dismissals that came through at this time. Good morning, you're John Dre Willis. And this is 25 DCCR 1048. Mr. Willis is charged with burglary of a habitation. What is the announcement?
Judge, I can, if you, okay. He was here on October 21st. The complainant in this case had signed a non-prosecution affidavit. She came to court that day, and during the pendency of the court process, she got my attention. We went to the back, and she said, I changed my mind. I don't want to do it. I want him to be held some kind of responsible. Based on that fact, I took that non-prosecution affidavit kind of out of the equation, and the court imposed the bond conditions by agreement
Yeah,
that the bond would be reduced at $7,500. He was to have no contact with her or GPS, and he had to go and live with his mom in Iberia.
Correct.
And we have the address. He has obviously not made that bond in the interim 6 weeks or so. She has not reached back out to me, but in light of that fact, I don't feel comfortable making the offer that has been requested for a misdemeanor. I would be willing to offer a felony probation with the same conditions pending a PSI. I just think a PSI would be important. I've tried to call her this morning with no answer. I can either make that offer pending a PSI, or I could ask you for 1 week and see if I can get a hold of her. I just don't want her to feel blindsided by it because she's gone back and forth. I'm not saying that she hasn't gone back and forth, but I think there needs to be some things in place. There was also a gun involved. We were able to determine that she actually found it, and it was not as big of an issue as we had initially thought, which is why my willingness to make the felony probation offer. I just think that's in my best interest.
so why don't we do this? I mean, I did reduce that bond, I've found that. Let's reset it to next Tuesday. See if you can get in touch with her, if that changes anything with regard to any agreements. And if it doesn't, then I would potentially reconsider that bond number to something that he was able to make with those same conditions. I think that would be proper for everyone's safety, but we could make the same conditions with the lower bond. So let's reset it to next Tuesday, and we'll see what the state finds out. Okay? We'll see y'all next week. Okay. You're Derek Williams. And Mr. Lewis, will your client waive the formal reading of the indictment?
He does, Judge.
So we're going to go through the indictment again because it's required. Mr. Williams, you're charged with the state jail felony offense of evading arrest or detention with previous convictions, and that is from August 14th of 2025. The indictment alleges you were previously convicted of evading detention June 4th of 2007. It further alleges that you were convicted of burglary of a habitation with intent to commit theft, a second-degree felony, February 1st of 2006. And after that was final, you were convicted of aggravated assault with a deadly weapon, a second-degree felony, December 10th of 2009. How do you plead to that charge? And are those prior convictions true? And did you enter your plea of guilty and true freely and voluntarily? And because you actually did what they've charged you with. I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them?
I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Move it.
It's admitted. Is there any evidence that Mr. Williams is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with previous convictions. Find those other 2 prior offenses true. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, sir. You can go back with the bailiff.
Thank you.
No, sir. Good morning, sir. Are you Luther Sharp?
Yes, ma'am.
Mr. Vasquez, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Sharp, in cause number 25, wait, are we going on count one?
Count one, Your Honor.
All right, hold on, let me, get that done. Okay, in 25 DCCR 0916, the state has elected to proceed on count one only. It alleges that you committed the second-degree felony offense of aggravated assault with a deadly weapon from May 26th of 2025, and how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Vasquez?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 15 years in prison, which means you're leaving your punishment up to me. And as long as I don't give you more than 15 years in prison, you can't appeal that. I can give you 15, I can give you less. It'll all be determined on the evidence and information that I receive at a sentencing hearing.
Yes, ma'am.
You have an absolute right to have a jury come in and do two things. The first is to determine if you're guilty or not. And then the second is, if they find you guilty, then you could leave your punishment up to them. If we go forward this way, you're waiving that right, and is that what you want to do?
Yes, ma'am.
Also, part of that agreement is that the state would dismiss cause number 25. Y'all wrote C, but I think you meant DCCR.
That's correct, Judge.
DCCR 0917. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Sharp is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for a sentencing hearing, and so the probation department can do a pre-sentence report. We'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Vasquez, and he'll present it to me on your behalf when we come back.
Yes, ma'am.
All right, you can go back with the bailiff.
Your Honor, can I speak?
Sure.
Would the court consider a bond reduction?
Not with a cap of 15 years in prison. Good morning. Are you DeMarcus Senegal? And will your client waive the formal reading of the motion?
You will, Your Honor.
Mr. Senegal, in cause number 20-33924, I have a motion to revoke your community supervision. Shows that you were placed on probation November 30th of 2020 for the offense of deadly conduct discharging a firearm, a third-degree felony, and that was a 10-year term in prison that was probated for 6 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you provided a urine sample June 2nd of 2025 that tested positive for cocaine. And is that true or not true?
True.
Count 2 alleges that you provided a urine sample July 3rd of 2025 that tested positive for cocaine. Is that true or not true?
True.
Count 3 alleges that you provided a urine sample August 14th of 2025 that also tested positive for cocaine. Is that true or not true? And then count 4 alleges that you're behind in your court-assessed fees. And is that true or not true? Did you enter your pleas of true to counts 1, 2, 3, and 4 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection?
It's admitted. Any evidence that Mr. Senegal is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 3, and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. I may have gone over that with you, but I don't think I started that in 2020. But because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff, and thank you for being here for probation as well. All right, sir. You're Derek Williams, right? Mr. Williams, you were given an opportunity to visit again with Mr. Lewis about what your position is with regard to what we went through. The possibility, if you go to trial, is a potential for 2 to 20 in prison if you're found guilty, and that the state had offered a 4-year term if you wanted to enter a plea of guilty. And so, what do you want to do? You want to go to trial. So there's a rejection that you need to sign with Mr. Lewis. Y'all get that signed. I'll call you right back up here and we'll get your case set for trial. I do want to make sure you understand, though, I mean, I know we already went over this, that this offer will not be accepted after today. If you're not guilty, that's fine. That's what juries are for. But I don't want you to think by putting this off, you're going to get some better deal. Okay. All right. I'll hold it while y'all do that. I'm sorry?
I was hoping to reach a plea deal today.
Well, the offer is what the offer is.
Understood.
Okay.
Yes.
All right. Y'all do that rejection, and then I'll take care of it. Mr. Galmore, you've got Melissa Taylor. Mr. Sharp, I want to make sure that you understand and know that I receive, the district attorney's office receives, your attorney will receive all of your disciplinary incident reports from the jail. I have 11 pages of them. So if you think you're going to come in and ask me for any type of consideration on that plea, my suggestion is between now and when you come back, I don't have any more added to this.
Yes, ma'am.
I don't have to take the 15 years.
Yes, ma'am.
We could go to trial and you could get worse.
Yes, ma'am.
A jury will see all of this.
Yes, ma'am.
You're too old for this nonsense.
Yes, ma'am.
All right, go back with the bailiff.
And that's how another unforgettable day inside the courtroom came to an end. Some people earned a second chance, while others were reminded that every choice has consequences. In the end, it wasn't just about punishment, it was about accountability, redemption, and the decisions that shape a person's future. If this case surprised you, let me know in the comments which courtroom moment stood out the most, and I'll see